So we have managed to cover 50 questions. Let us take a deep breath. जिसे याद आता है, you should also take deep breaths throughout your examination. You must remain calm. Now, since you have been staring at question number 51, let us go ahead. Local laws ने आपके एग्जाम के बॉक्स ऑफिस पे ओपनिंग कर दी है. We have to deal with MP Accommodation Control Act for the next 5 questions. Now, question number 51. If a tenant makes deposit or payment as provided by section 13(1) or 2, no decree or order shall be made by the court for the recovery of possession of accommodation on the ground of... Oh my god. The correct answer was A. Now, let me tell you that this is a question which looks complex, but the simple question that is being asked, जो आपसे पूछा जा रहा है वो ये है that tenant has made the deposit. Now you have to identify as to under which provision a tenant can be evicted on non-deposit of rent. अगर rent deposit कर दिया, so the natural conclusion would be that he cannot now be evicted for not depositing the rent, right? Now while we will deal with the grounds of recovery of possession, here you only had to remember that this particular ground, not depositing rent, is mentioned in 12(1)(a), which was the correct answer. Even by logic, non-payment of rent should be the first ground, as in 12(1)(a). Going forward, so question number 52. What is the time period within which no suit of eviction can be filed under section 12(1)(e)? Right, where the landlord has acquired an accommodation by transfer. So the correct option was C. The period is 1 year. Now, as promised, we have enlisted all the grounds here and below which are used or which can be used for recovery of possession. Now you can have a good look over here. Coming back to the question, so as per section 12(4), this period is 1 year, after which a suit for eviction can be filed under 12(1)(e) or F. Very well, it is actually exciting to see questions from the definitions. Question number 53. It is kind of something जो आपको हमेशा देखना चाहिए in every legislation, the definition section. So now look at the question, which of the following statement is correct? So 3 of them are definitely false. Now, married daughter is a family member. As per 2E, no, of course not. However, an unmarried daughter is definitely a family member. Now, a sublease is definitely included in a lease as per 2D. Further going ahead, a garden is in fact part of an accommodation as per 2A, and any land which is not used for agricultural purposes is of course covered under accommodation as per 2A. I hope you knew that. Quickly wading into question number 54. Now keep the breath steady and have a look. Now this question looks big, but we can easily crack it. So which of these following statements is false? So we have 4, so 3 are definitely true. Now let us proceed with A. So when we proceed with A, we see that this is exact replication of section 12, and when we look at B and compare it, you see in the contract to the contrary, this is an unnecessary addition over here. You can easily pick it out, and you do not even need to waste your time on options C and option D. So you have cracked the question and you have saved time. In fact, I am dead sure that the last addition in option B was something that caught your eye and you went for it. Kudos if you did. So moving ahead, question number 55. So the MP Accommodation Control Act 1961 does not apply to, well, it will definitely apply to property of municipal corporation used for residential purpose. And section 3 of the act will tell us that it does not apply to government property or property of a local authority used exclusively for non-residential purpose. This was a direct question from section 3, so we had to rule out B and C, and that will give us the correct answer, which is D over here. So with little logic also, I am sure that you could have hit a home run. Now a quick tip. You go through one Rent Control or Accommodation Act, you can get a good hang of most of such laws, which in principle are similar or have little variation. In any case, we have strived to make our content on local laws into national bestsellers. While that was a packaged joke, do check us out. Question number 56. Now this marks the beginning of the MPLRC. So in which of the following matters jurisdiction of the civil court is not excluded? Focus on the not over here. Now we can do this one by one, picking out all the relevant provisions also. So ejectment of government lessee. Government lessee is there in 181, ejectment under 182.2. Now specifically provided under 257M that revenue authorities will have jurisdiction. Restoration of possession of an occupancy tenant 170A by collector. Any claim to modify any entry in Nistar Patrak specifically by revenue authorities 257W. Now Nistar Patrak is something that will govern the use of land, let's say for the purposes of collection of timber, firewood, etc. Lastly, option D, partition of holdings specifically provided under 178. So when there are more than one Bhumi Swami in a holding, they may apply before the Tehsildar under 178. Arrested with which application the Tehsildar may stay the proceedings if there is a dispute of title involved. So in such matters, jurisdiction of the civil court is not ousted. You see, even otherwise, if this is a question regarding title, the competent court would be that of the civil court, which would in fact adjudicate upon the title of the land. Now trust me, I understand that question number 57 was a difficult one. The examiner couldn't exactly be kind, right, all the time. So who among the following is not a revenue officer? C was the option over here. A revenue inspector as per section 11 is not a revenue officer. We have laid down the following classes of revenue officers for you, as well as the additions in 2018. Now you have to remember that you must be recent with your studies. Any legislation studied is a wasted hard work if you weren't studying the latest act or are ignoring a recent amendment. So this was directly from the 2018 amendment. Coming to question number 58, where a partition proceeding is filed before the Tehsildar and a question of title is raised. I am applauding if your mind is saying 178 or 3 months or something like that. So the clear answer here is that he shall stay the proceedings for 3 months, facilitate the institution of a civil suit for determination of question of title. Now, of course, the Tehsildar cannot proceed to partition the holding in accordance with the entries in the record of rights. He is nobody to invite a decision on title as well. Clear and cut answer here was B over here, and D was there just to confuse you. As you can see, the question of title is very vital and has to go before the court of competent jurisdiction, which is the civil court. Now, you do not need to check out the MPLRC right away. We have you covered with our depictions. I am positive that next time around local laws would sound more fun than scary. Question number 59. A Bhumi Swami may transfer an interest in his land. Now by way of interest, I think we can exclude option B. Note that answer A was the correct one. By way of lease, even if the period of lease does not exceed 5 years at a time. So section 165 says that Bhumi Swami can transfer any interest in his land subject to conditions which are stipulated in subsection 2. Now a mortgage is valid if some land is left with him. How much land? So unirrigated will be 10 acres and irrigated 5 acres. Now you can remember option C was unirrigated lands but 5 acres only. Now usufructuary mortgage is valid only if it is for a period exceeding 6 years. However, it is coupled with the duty to redeliver the land to the Bhumi Swami. Now section 168 is your basis for answer number A, which was the correct one, that period of lease cannot exceed 5 years. Now in the event that the lessee is not handing over the possession, the Bhumi Swami shall be deemed to be improperly dispossessed and he can go for filing of reinstatement under section 250. I think this explanation will set you good. Now question 60 is a tad bit difficult, directed directly from a provision which isn't there anymore. Let's mark option C, which is the correct one, and again consider what we could have done in any case if we did not know. So a widow who is an occupancy tenant, so it is a transfer related to a occupancy tenant. Now by virtue of there being a tenant, you can easily rule out A, because tenants cannot sell, tenants cannot gift. So A and B are gone. You only were left with C and D. I hope you were able to mark C. So from question number 61, we start our journey into the Evidence Act. I am sure after reading question number 61, you were directly able to relate it with section 3 of the Evidence Act. So the correct answer here was D. Now as you can also see, we had this covered in our question bank. So a fact is said not to be proved when it is neither proved nor disproved. I am positive it is etched in your memory. So confession के zone में आ गए हैं हम with question number 62. So section 27 is the exception to which rule? You know, 24 to 26 में ये rule है. 24 will talk about confession by inducement, threat or promise. 25 will talk about confession made to police officer. 26 will talk about custodial confession. So the correct answer was D without any doubt. Section 25 को याद रखेंगे आप. We will also refer back to it in question number 75. 1 minute में let us understand the exception. So मैंने चोरी की, I stole something and then I confess that sir, I have kept the stolen goods in so and so room of my so and so friend who resides at so and so place. Now as per my confession, a recovery of stolen goods is made. So this is relevant and it may be proved. Question number 63 is talking about best evidence rule. Forgive me if this sounds cringy, but saral bhasha mein this means that I am the best evidence of my existence. Evidence Act regards primary evidence as the best evidence, which is in a way embodied in section 91 of the Act, and so D was the correct answer over here. For a contract or for the terms of a contract, the best evidence is the original contract itself. As you all know, provisions have exceptions, even this one does, such as the appointment of public officers or probate of wills for that matter. That apart, did you know that in practical and common arrangements, a contract would always have more than one document, including maybe the letter of intent, notice inviting bids, the bid, offer, acceptance, work orders, so on and so forth. So this section would apply to all such documents forming part of an agreement. That apart, often compromises are executed in more than one originals. However, as per this section, you will have to prove only one. Coming to question number 64. So how does the Act treat witnesses who are unable to speak? Well, they can give their evidence in writing and it will still be treated as oral evidence. Option B was the correct answer as per section 119 of the Indian Evidence Act. Try imagining the problems we would face if it were treated as documentary evidence instead. Question number 65 is a direct one from section 10 of the Indian Evidence Act. We had covered this in our question banks. So section 10 would make the following facts relevant in proof of conspiracy. There has to be a prima facie evidence making a court believe that there is a conspiracy. So in this timeline, anything said, done or written by any one of them in reference to their common intention will be evidence against the other after what I've stated has happened. Now this timeline will cease after the act has been committed, so that will not be relevant as per section 10 of the Evidence Act. Going further and coming to question number 66, so which of the following could be proved as dying declaration after the death of a person? FIR lodged by the person, certainly. Statement of the person under 161, definitely. Statement of the person recorded by executive magistrate, yes. So the correct answer was D, all of these. So dying declaration is the last statement of the victim or deceased before his death regarding the incident. As you can see, it may be recorded by a doctor, a magistrate, or even a police officer. Coming to question number 67, so public documents are a matter of section 74, which is option C over here. This may be an easy to remember depiction of the same. Note that an original sale deed is a private document under section 75, however. Now let us quickly depict by examples as to what all would form, what all would not form public document for you. I think you would find the illustrations quite interesting. Coming to question number 68. So you had question 68 within your grasp if you immediately guessed expert witnesses, or if it came to your mind for that matter, and you had to mark option D over there, which is covered in section 45 to 51. You see, we were careful to not miss it in our question banks. Now, how would you know if Babu Rao ka signature is Babu Rao ka signature? Yes, you will call in an expert. This brings us to question number 69. So you've already seen this before, right? A document forming the acts of an employee of an educational institution is certainly not a public document. D was the correct option over here. This would now bring us to question number 70. So again, we have to identify which of the statements is not correct. So 3 of them are correct. So a rule of law cannot be nullified by resorting to a doctrine of estoppel. Yes, Assurances held out but not incorporated in an agreement would not attract doctrine of estoppel, certainly because they did not form part of the agreement. Now, an estoppel arises as soon as the relationship of the landlord and tenant is created. Yes, after this, tenant cannot deny the title of the landlord. So C is the correct answer over here. A plea of promissory estoppel is not available if the officer of the government is acting outside his scope of authority. This is covered under section 115 of the Evidence Act. This principle envisages a party acting upon a promise and doing something in furtherance of that promise. In such a situation, the other party would be estopped from going back on what it had to perform. So TIP under the law of evidence is actually corroborative evidence. Option B लगाना था आपको. This is in a way envisaged under section 9 of the Act. As you can see, we have also covered this under our question bank. Now, TIP is an essential tool with the investigating authority to establish the identity of persons relevant to a trial. Now, yes, persons are often lined up for such TIPs. Coming to question number 72, the general rule is that confession of an accused is only relevant against him. The exception, however, is enshrined under section 30. For you, option D, you must have marked it. So this is your ideal Chote Mian and Bade Mian pulling a heist together. One of them confesses. It will be used against him and the other as well. And the court can consider the same against the one confessing as well as the others. But there are some parameters to this as well. They have to be tried jointly for the same offense, and the confession must in fact affect the confessioner and others as well. Now at question number 73, we have a retracted confession which cannot be made the sole basis of conviction even after corroboration. So B was correct over here, that it cannot be made solely the basis of conviction under any circumstances whatsoever. So यहाँ पर आपको option D लगाना था, that both 1 and 3 are incorrect. So a retracted confession is when the accused confesses at the pre-trial stage regarding commission of the offense, however retracts at the stage of trial. Now the evidentiary value of this requires that each circumstance be separately and independently corroborated in material particulars for a retracted confession to return conviction. You would be surprised to know that under the English law, an accused person can be convicted on the basis of retracted confessions. This brings us to question number 74, which is talking about the necessity rule envisaged under section 32 of the Evidence Act. You had to hit option B over here, which was the correct option. Now, dying declaration is understood as something which is an evidence of sterling quality and bears 100% truth, because a man on his deathbed will not lie and will be speaking the truth. Coming to question number 75, have you been waiting for this? I have been. I have also told you that we will come back to section 25 of the Evidence Act when we discuss this. Now we must devote some time over here and read the entire question. So in a murder case, before identification of the culprit, B wrote a letter of confession to the police officer. At the time of writing the letter, there was no suspicion cast on B. Very relevant. So you have to choose the most appropriate answer from the following choices. So let me first mark the correct answer. It is inadmissible as it was made to a police officer. A was the correct answer over here. However, at the same time, I wonder if this was your face when you read this question. You see, section 25 coupled with this question is a bit tricky. So the confession has to be made by an accused person to a police officer for coming within the protection envisaged under section 25. Now often there is doubt as to whether who is a police officer or who is the accused person. So this can be taken care of with Sitaram versus State, AIR 1966-1906. You can have a look, as well as Agnu Nagesia versus State of Bihar. Now what I want you to have a look at is the landmark judgment of Deoman Upadhyay in AIR 1960, Supreme Court, page 1125. Now you have to specifically look at paragraph 6. Paragraph 6 will tell you that an accused is not just a person who is named or not named, but any person against whom the police would be gathering evidence. So in this case, even though at the time of making the confession B was not the named accused. The police were gathering evidence against him, so he in fact will be covered under the protection granted by Section 25 of the Evidence Act. I hope I have offered some clarity.